Personal Protection Order or PPO. What you need to know if you have received a summons for a PPO. The summons is a court order directing you to attend court to answer to the allegations of family violence made against you by the applicant of the PPO. You are known as the respondent. The applicant could also apply for a Domestic Exclusion Order or DEO. The DEO is an order that prevents you from entering your home or specified parts of it. There are 3 stages of the court process you will need to know. Beginning with the summons stage. On the summons, you will find the date and time you need to attend court. This is called the mention. If you are unable to attend on the appointed date and wish to reschedule the mention, you can apply to court via the IFAMS system to explain why you cannot attend court and attach the supporting documents. If you choose to engage a lawyer to represent you, you should do so as early as possible. Next is the court mention stage. Arrive punctually for the mention. If you are late or absent, the judge may issue a warrant for your arrest. The case will continue after the police have arrested you. Alternatively, the judge may direct that the case proceeds without your presence. At this stage, the applicant may consider withdrawing the application if he or she no longer wishes to pursue the case. If you and the applicant are present, the judge may refer both of you to a court family specialist for counseling. In court, if you admit to committing family violence and consent to a PPO, the judge will grant the PPO. The judge may also order that you, the applicant, or the both of you to go for mandatory counseling. If you do not admit to committing family violence, the judge will order that the case proceeds for hearing. In preparation for this, both you and the applicant will have to attend a second mention. At this mention, both of you will provide documents to support your respective cases, if any. These can be police and medical reports or any other relevant evidence. The court hearing is likely to happen 4 weeks after the second mention. On the day of the court hearing, this is what can happen. If one of you is absent, the judge will deal with the case in the same manner as in the mention stage. If both you and the applicant are present, the judge will proceed to hear the case. First, the applicant will present his or her case and evidence. This is called the examination in chief. Once done, you can ask questions on what the applicant has presented. This is called the cross-examination. Next, you will present your case and the applicant will get a chance to ask questions. If any of you are represented by a lawyer, the lawyer will do the examination in chief, the cross-examination, and a re-examination. The re-examination, if any, will happen after the cross-examination, where you or the applicant may be asked additional questions to clarify your answers. Lastly, each of you or your lawyer may sum up your respective cases before the judge. Once done, the judge will make a decision. The judge will grant a PPO if he or she is satisfied that family violence has been or is likely to be committed, and a PPO is necessary to protect the applicant. The judge may also order that you, the applicant, or the both of you to go for mandatory counseling. If the applicant has applied for a Domestic Exclusion Order, the court may grant the order. The order excludes or restricts you from entering your home or specified parts of it. If the judge is not satisfied that there was family violence or that a PPO is necessary, the case will be dismissed. Breach of the order is a criminal offence. This means you can be punished with a fine and/or an imprisonment term. For more information on the PPO application process, visit the FJC website at www.familyjusticecourts.gov.sg, or you can download a copy of the PPO booklet from the website.